Hi everyone, my name is Ral Obioha. I am an immigration attorney based in Houston, Texas, but I represent clients all over the country. I say this all the time, but the reason why I can represent clients everywhere is because immigration law is federal law. And so, any attorney barred in any state. I am barred in Texas and Maryland, but when you're dealing with federal law as an attorney, you can practice in any state as long as it's the same law. All right, so now that we read that little snippet as to why immigration attorneys can be from anywhere, can be based from anywhere in the United States as long as they are barred in a U.S. state and legally barred. We can move on to the topic. So today I want to give you a very brief video as to something that I've been getting a lot of questions about recently. Now, one of my recent videos talked about U.S. citizenship and qualifying for U.S. citizenship. One of the requirements or one of the elements for qualifying to be a U.S. citizen is if you have physical presence, if you have qualifying physical presence in the U.S. Another one is if you have continuous presence in the United States. Now, people get that confused a lot, like physical versus continuous. What does that mean? This video is going to explain that. If you're applying for citizenship and for example, you're applying under the 5-year rule, meaning that you acquired, your green card 5 years ago or 4 years and 9 months ago, which is the earliest you can apply based on the 5-year rule. There's a requirement that during the statutory period is the 5-year period. During that period, you have to have maintained actual resident in the United States. That means that if you calculate your time in the U.S., not time away, you calculate your time in the U.S. for the past 5 years or 4 years and 9 months, if you're applying based on that, you have to have been in the U.S. at least 30 months out of the 5 years, which is basically half, because 5 years has 60 months, I think. I'm not good at math, but 5 years has 60 months, I believe. And so it means that you have to have 30 months on the books, 30 months of actual presence in the United States. If you don't have 30 months for that 5-year, based on the 5-year rule, you will not qualify for citizenship. You will be denied citizenship. So that's an issue that a lot of our parents who have legal permanent residence but travel a lot to their home country, that's one of the issues that they have. So if you have a parent, you should advise them, mom, dad, sit down in the U.S. for a good amount of time so that we can get you citizenship and then you can fly wherever you want to fly and stay however long you want to stay. But that's one of the issues that is recurring with a lot of immigrant parents, especially those who are older, who are used to being away. They want to be in the U.S., but they also want to be in their home country. So it's like they have one foot in and one foot out, and it usually costs them at the end of the day their green card status if it's not done properly. Having said that, on the other hand, another requirement is the continuous presence. People don't calculate this before they apply. I tell you, so many times people come to me after they receive the notice of intent deny, and they say, well, I thought I had 30 months in the U.S. in the past 5 years. Well, that's not the only requirement. Another requirement is continuous presence. Continuous presence as opposed to physical presence doesn't mean that you were actually physically present in the United States for all that time. It means that in addition to it, your dealings, so to speak, show that your home is in the U.S. So one way to prove it is the fact that whenever you travel, you're not gone for more than 6 months out of any year at a time. So, or any year, actually. So if you travel to, let's say, your home country and you stay there for 6 months and 5 days, that breaks your continuous presence. And so you kind of lose that year when you start to calculate backwards when it's time to apply for citizenship. And so it's important that you advise your family and friends when you're on a green card, you don't travel for more than 6 months at a time or cumulatively more than 6 months out of any given year. So that's something to definitely consider. Another thing to consider is the fact that when you constantly when you're constantly traveling, so it just looks like you're hopping from place to place to place to place to place, and they can see it on your CVP record. You should have good reason for it. And there's a way to document that if it's for work, if it's an emergency for family, something. You should document the reason why you're out of the country more than you're in the country, because continuous presence means that you're in the country. Now, in certain situations, if there's numerous travel, or maybe once or twice there's travel that exceeds 6 months out of any given year, you can dispute it, you can combat it. And the way to fight that is by showing that your dealings are here, your home is here. Do you have bank accounts here? Do you have a lease agreement? Do you have mortgage here? Do you have hospital bills? Do you have insurance? What evidence do you have? Is your family here? What evidence do you have to show that your travel was only temporary? That you're not basically living somewhere else and claiming to live in the U.S. So, I've been able to overcome some notice of intent to deny. Basically those letters that say we're going to deny application unless you tell us the reason why not to. I've been able to combat a lot of those based on insurmountable evidence of maintenance of continuous presence despite some long trips. Now, if you're traveling like 8 months out of every given 5 years, we can't overcome that. But if there are limited circumstances that we actually have evidence to explain why those circumstances occurred, such as a family emergency, a death in the family, something, then it's definitely, you can overcome it. But hope this has explained to you the difference between actual presence and continuous presence. So actual presence means, for example, if you're applying based on the 5-year rule, that you have maintained 30 months actually present in the United States. And the continuous presence means that you have conducted yourself in a way that shows that you actually reside in the U.S. Even if you're traveling a lot, it shows that you actually reside, because you can have the 30 months and fulfill the actual presence requirement, but not have the consistency to prove the continuous presence requirement. So these are two different beasts that both need to be met, and these are not the only two requirements for citizenship. There are other requirements, but this video was only to explain the difference between these two, and I hope that I've been able to explain today. If you have any further questions and you'd like to consult with me, you can reach my office at 832-569-1110. Please also follow us on social media, on Twitter, on Facebook, on Instagram, at Ral Obioha Law. I hope that you will apply for citizenship if you're qualified, but that you consult with an attorney before you decide to apply, to ensure that you qualify and that you meet all the requirements of the citizenship application before you waste your money or waste your time. All right, this is Ral Obioha of the Law Office of Ral Obioha. I hope that you have a lovely day. Bye.